lucky to have attorney Allan Lolly with us today. Allan is a former criminal prosecutor and civil trial lawyer. But for the last 20 years, he's been an immigration lawyer and has familiarized himself with all the ins and outs of the Adam Walsh Act and how it affects immigration issues. So we're very, very fortunate to have someone who's really focused on this specific area of the law with us today, and we want to thank you, Allan, for being with us.
Thanks. Yeah, hi, I'm Allan Lolly. The reason I'm here is because these Adam Walsh Act cases are extremely difficult to receive approval from the USCIS. Federal litigators have been into court quite a bit about litigating aspects of the Title IV Adam Walsh Act, which is the immigration consequence provision. Haven't done very well. And so I've worked on these cases since 2006, very slowly, because I have a small law office, and we don't have the larger staff that some of the bigger firms might have. But I have a serious interest in the Adam Walsh Act cases because I don't like abuse. I don't like abuse as a prosecutor from individuals, and I don't like abuse of the government either. So I find these cases involving the Adam Walsh Act immigration consequences interesting to me personally, just from a legal analysis standpoint. So, and by the way, it's not just my interest, but these cases, it's really difficult to get an approval out of USCIS, and you'll see from the handout, I've listed, I think, 11 cases, 10 of them are USCIS approvals straight out of the USCIS. Well, some people think that it's an extremely rare occurrence, or like a unicorn, walking in the door, if you get an approval for an Adam Walsh Act case for any attorney across the United States. Those 10 cases that I've listed are the ones we pulled up that are more recent. We've got older ones as well. So, I mean, we've had some success in working on the Adam Walsh Act immigration cases. They're still tough. So if an attorney somewhere across the United States gets an approval on 1 out of a million, and I've got 10 or 15 out of a million, it's still a dozen out of a million. And I'm exaggerating, but the point is that I've had some measured success in working with the USCIS in trying to get approvals as compared to some other offices. And that's why I was asked to come and talk about it. First thing I want to know is why people are here. Who has foreign family members that are trying to immigrate? Okay. A couple. Who doesn't? Are some people here just for curiosity? Okay, just curiosity. Okay, interesting. Okay, well, I would be glad to take your questions anytime you have them. And in the meantime, I could sort of give you an introduction to what I'm doing with immigration on the Adam Walsh Act cases, because Adam Walsh Act doesn't behave like a normal immigration case. So I would say that there are some really smart attorneys that are immigration attorneys across the United States, really great federal litigators, and really great U.S. attorneys that are working for the government. Adam Walsh Act cases take a twists and turns that kind of go off-roading. And I think the reason, perhaps, that I've been a little bit more successful than some others is that I don't necessarily put on my legal hat when I'm looking at immigration things. I did well in law school. I was near the top of my class, and so I can be an academic, and I like academics. And I really like the constitutional issues, to get into them. But when I'm working in a small office, I don't have the luxury of doing that because I have to run a business. That's how it is. So it takes me a long time to do legal research, longer than it would for some other offices. But because I have an interest in this area, I spend my off hours or weekends or so forth trying to learn what I can to prepare, because what I've seen go into court, in my view, is not adequate. These are tougher cases than what I've seen go into court. So sometimes attorneys will latch on to legal theories and they'll say, we'll try to run this legal theory or that legal theory. And the question is, what exactly is the problem? So I want to take a look at the stat. Oh, by the way, a typical question for somebody is, what's the fact pattern? or what kinds of cases are getting approved, what kinds of cases are getting denied. And if you look at the approvals that we've gotten out of our office, I can't make rhyme or reason out of it. So I don't see a pattern. What I see is that if you prepare a case that's submitted that is 98% perfect, in other words, you've got a really compelling case, and most of the submissions that our office used to do, and some submissions that other offices do, are okay, but they're not compelling. They're not at that level of perfection that you're going to get anybody's attention. Yes, sir.
I mean, interrupt you, but define compelling. What's compelling?
Thank you. Let me get into that in a second. So first thing is you have to have a really compelling case, and that's the good question. What is it? The second thing you have to have is an audience who will listen. So if you have, let's say you have a 100% amazing case, this case obviously should be approved. But the person who's your audience has zero chance of approving your case. In my mind, it raises legal questions. So I think where we've had some more success is that we've been able to present compelling cases, and on the other end, the audience who might be listening may be open to hearing what's being said. And so there could be a difference, for example, and this is my imagination because I don't get to talk to the officers. I've actually talked to a couple officers that have approved cases and have tried to get an understanding of what they're thinking. But it tends to be in my mind that you've got USCIS officers who aren't afraid of their job. Maybe they've been there for a while. Maybe they're a little bit older, have life experience. And they realize that there is no perfect life. There is no, they're at least willing to stay on the page and read through what you have, and then make their own decision whether or not they think they should be approved. And then there's other officers who for whatever reason, they're not going to approve anything. And if you file the perfect case and that officer's not going to approve anything, then that's the lot that you have with that particular officer. Also, you have officers who are wanting to make supervisor, or they want a pay raise. The way that the standard operating procedures are written is that if you deny a case, you don't have to have supervisory review. If you approve a case, you have to have 2 levels of supervisory review. So there's an incentive just to deny the case. So this is what we're up against. So I try to present compelling cases, and sometimes they don't get approved. Sometimes they do get approved. So the question is, what's a compelling case? I've got in your handouts there some information about what I believe, when I'm working with clients, what I believe makes a court case. And then I want to go back and take a look at the statute itself in a minute, but we can jump through that really quick. Let me toggle through some of the screens here. Okay, what is likely to make a poor AWA submission? When I'm working on cases, if you imagine, let's say somebody has a crime involving a minor child that doesn't involve aggression or violence. So this is a 2-step process. Number one, from a USCIS standpoint, well, some people say, for example, that the Adam Walsh Act was created to protect children. So if I'm immigrating a parent or a spouse or a fiance or something like this, what does that have to do with the purpose of the statute? Well, the purpose of the statute, the way the statute's drafted, is 2 different things. So the first question is whether the petitioner, the person who's trying to immigrate a foreigner, whether that person has a specified offense. If they've been convicted of a specified offense, and that's a whole list of stuff. So if you fall into the bucket, then the separate question is, and it's a totally independent question, is does the petitioner pose no risk to the foreign beneficiary? Okay. So there's not necessarily a connection between what gets you into trouble and how you're supposed to dig your way out of it. And so that's how the USCIS interprets statute. Okay, is that the right way to do it? Probably. Okay, so once you got that case where you're trying to show that you pose no risk, some of the pitfalls that I see is that I have psychologists saying, Mr. Smith poses no risk to the foreign beneficiary. I think that's a mistake, because I think there is no such thing as no risk. If you go walking down the street, you pass somebody going the other direction, there's a risk. They could kick you or hit you with a frying pan or something. So when we're talking about human affairs, unless you're dead, you pose a risk. Everybody does, right? So one of the difficulties I have with USCIS officers, also psychologists and clients as well, but USCIS officers who are deciding on cases is they're thinking, well, if you haven't shown that you pose no risk to the safety and well-being of your foreign spouse or beneficiary or whoever it is, if you haven't shown that, then you lose. But if there's an absolute standard of what posing no risk is, then it's not really a choice. So Congress said, if you fall under the Adam Walsh Act, you got to dig your way out. And if an adjudicating officer says poses no risk means no absolute risk, then there's no way to dig yourself out if you're alive. So that's just how it is. So that becomes a litigation issue about what does it mean poses no risk, right? Like how do you unravel that puzzle? So this is why on the one hand I want to present compelling cases. On the other hand, you have to do that if you ever want to get to court. You don't. If you're 90% right, the government's 10% right, government wins. So you have to have a very tight case just to get somebody to listen, to what you have to say. So, okay. So there is, in my book, there's no such thing as poses no risk. So the question for the psychologist is, in my view, is there a basis for concern? So if you have a sex offense involving a minor child that has no aggressive component, let's say Romeo and Juliet, 20-year-old dating a 15-year-old, something like this. For example, I had a case where the mother was okay about her daughter dating a 20-year-old, it was fine, but her father was a police chief, was a fire chief. And when he found out about it, boom, straight to the police. So the 20-year-old parent, shouldn't be involved with a 15-year-old under law. How egregious are we talking about? What's the level of concern that there is for a risk to aggressive behavior or violence, or domestic violence, or anything happening inside the home that might cause a problem? So what I ask psychologists to do is not focus on the words no risk unless you're going to define it. If the USCIS is not going to define the term, which is a question why they're not defining the term, but if they're not going to define it, then we have to define it on our end. If by poses no risk you mean the lowest risk level, or 2% or 3%, or whatever percent you want to come up with, that's okay, but that's for the psychologist to discuss. What does the term no risk mean? So if there is what I'm thinking is, if there's no aggressive or violent behavior in it, and the purpose of the Adam Walsh Act is to protect the beneficiary from safety, like a safety issue. And if that's not a concern, then what I ask them to do is, don't say poses no risk, just say there's no basis for concern. If there's no basis for concern, the question for the USCIS is, what are you doing? If there's no red flags going off in terms of domestic violence or safety issues, or emotional abuse or something like that, then how would this person not be able to climb out of the bucket? So that's one of the areas. Another area, when I'm working with petitioners, for example, is petitioners will see the case as being very simple. And in truth, these cases can be really simple. If you take the law out of it, you just look at the case, the question is, does this person who's been living in the same house with their spouse for 13 years, which I got one of these cases, we're just in the process of filing it. Well, we've actually filed, we're supplementing, because the USCIS is allowing a further supplement. We've got over 1,000 pages on that case. But the point is that if the petitioner is focused on the idea that I don't pose a risk to my spouse because we've been living together for 13 years, then they're not understanding how the reader is viewing them. So in other words, sometimes for petitioners who say, well, this offense was 20 years ago, I don't even want to talk about it. That's not what a USCIS officer is looking for. What the USCIS is looking for may have nothing to do with the risk determination, but it has human elements. What they're thinking is, do I want this petitioner living next door to me? I've got kids. Do I want them living on the moon? You know, why should I read these documents that you're presenting when I've got lunch at 12? So if I deny the case, maybe I can get out of here quick. So that's really, I think in part, I think many USCIS officers actually do their job, they do a good job, and they read the details. They'll sit there and do it. But as an audience, you have to present to them something they're willing to listen to. And what are they willing to listen to? I had a psychologist recently say what we could do is package something together. As soon as I hear the word package something together, I said, I'm not listening, I'm off. I'm not involved in that. What I want is transparency of the truth. Inside a relationship, inside the home, everybody has stress. There's always arguments, there's always some, Natalia and I were arguing this morning. I mean, there's always stuff going on in people's lives. And if you say, oh, we have the perfect life, a relationship is good, there's nothing to see here, nobody believes it. So now you've got a USCIS officer who's checking out, they're thinking about lunch now, because what you're saying isn't true. Or at least it probably isn't true, because that's not our human experience. Our human experience is the granular relationship that people have inside the home, whether it's parents or fiancés or spouses or whatever it is. And that should come out and be put on the table for discussion. That's why our affidavits can be 20 pages long. 40 pages, maybe you don't want to read it. Maybe 20 pages you want to read it, but it has to get into what your life is actually about. Also, so what I'm saying is that USCIS officers are looking for transparency. How can they make a decision if they don't trust what you're saying? So the only way they can trust what you're saying is if you put all your cards on the table. So I work with clients a lot because there's things like, writing styles or how to present is one thing, but also buried past that they don't want to bring out. There's things about the relationship that needs to be clarified and put on the table. We spend a lot of time telling the story of the petitioner, but it's not my story. It's the story that they need to tell. So what I do is I ask a lot of questions. I just go through and keep asking more and more questions. And what we're trying to do is figure out what is the story. Like, it's not just about the relationship, but for the criminal offense itself. Police report says one thing, indictment says something else, the plea appeal says something, like a hybrid, and the petitioner ends up in therapy. He's got another story about what happened, and you're looking at the facts from the police report all the way through therapy. The facts aren't matching up. And so the client sometimes says, well, then I just admit everything. Like, I don't want you to admit everything. I want you to tell me exactly what happened and what didn't happen. And sometimes someone will say, well, what was in the police report didn't actually happen. But my criminal defense attorney said that I have to plead guilty, so I have to be able to say certain things. So I don't want any of that. I want you to tell me what happened. Okay. So I will have, for example, a client who explains the history of how they, from childhood, I go from birth. I don't care how far back we have to go, but I want to know what led to that point where you ended up getting involved in the criminal justice system. So if I can understand the disposition, the character type, and the way that person behaved and what their thought process was, all the way through to the criminal event, then during the criminal process, how did things end up going in a direction that's not, that doesn't really reflect the facts from the petitioner's honest point of view, and not from their wishful thinking or from covering up little details that actually happen. We all do that. Every single day I probably skip over, little issues that I've done that seem incorrect. But the more that you bring those imperfections onto the table and discuss them, the more likely it is you're going to keep the reader's attention. And the more likely it is the reader's going to start believing in what you have to say. And so I had, for example, a client, I've had a number of, but this is an example in Texas that kind of stood out. Because the guy said, I actually didn't do it. And I said, he said, but I'll say that I did. And I said, no, I don't want you, if you say you didn't do something, don't keep saying that you did, because tomorrow they may pass a law that said everybody who did that gets hung. You know, so the more that you keep massaging the facts in a way that doesn't actually fit what you honestly believe happened at the time, the more you're digging a hole for yourself that in the future you can't unravel. So there's an issue there about being honest about what occurred, and I was talking to a psychologist about that particular case in Texas here, and she said, yeah, it makes perfect sense to me. And I said, why? She said, because I've been in psychology in the criminal justice system for 30 years. The treatment center that he went to, I know who he saw. They don't let anybody out. The fact that this guy got approved, they're running a racket. In other words, they keep you in the treatment center because they're collecting money. So she said it was actually remarkable that he got cleared to leave as soon as he did. And she said, I'm familiar with the way the prosecutor, she said, this case is 20 years old. She said, I was around 20 years ago. I know how they were running these cases in the prosecutor's office at that time. And so what he's saying makes a lot of sense to me. So this is an example of what to do with psychologists. So psychologists have these templates, you know, where they run their mechanical tests, and they run their personality tests and their MPI, and there's their static tests and dynamic tests and all this stuff, and then they come up with their conclusions, right? Yes, they have to do all that because they have to do risk determination. But my question for her is if what this client is saying makes sense from your point of view, given your history and experience involved in these kinds of cases going back that far, can you talk about that in your psychological report? And she said, normally I don't do that. And I said, yeah, we're going off-roading here, but it validates what he's saying. And she said, yeah, I can do that. I don't know what the case may still be pending or something, but I don't know the result of that. But the point is that I have to be able to get the petitioner to put their cards on the table and look at Adam Walsh Act cases as more than just I have a love relationship and I want to be together with my spouse or my parent, you know, whatever it is. And so you should approve me because Adam Walsh Act is about children. No, that kind of thinking isn't going to fly. So from an adjudicator standpoint, from a USCIS standpoint, think of a Judeo-Christian model where you have to confess your sins, go through trials and tribulation treatment, whatever it is, and be resolved. In other words, for an officer to say, I don't mind you living next door to me, in our cultural thinking, what does it take to be fully resolved and redeemed? You know, what's the redemption? Psychologists say that has nothing to do with the risk determination. In fact, I've had several psychologists tell me that treatment doesn't change the statistics. So if you look at the statistics of recidivism when it comes to sexual offenses, I'm thinking, well, the treatment allows you to, you know, theoretically come to God or admit what you've done and sort of resolve it and move on in life. And he said, yeah, that may all be true, but statistically it doesn't make a difference in terms of recidivism. And I said, okay, well, if that's true, so why do you have the treatment as part of the criminal justice system? And he said, because it's a cottage industry. So it's something, in other words, if a judge is sitting there and the judge has to impose punishment, then what can you do? Pick up trash, you gotta pay a fine, you gotta spend some time in jail. Treatment sounds like that sounds like a pretty good thing to put you through. And in fact, it probably, we all should be in treatment in one way or another for everything. You know, so treatment is not necessarily a bad thing. All this psychologist was saying is, from a statistical point of view, it doesn't really make a difference in terms of recidivism. And so the idea of coming to God and having salvation isn't really part of a psychologist's work. And I said, you need to, you know, please keep these things separate. He goes, well, why are you going into this model of petitioner confessing and doing all this stuff? And I said, because the USCIS adjudicator has their own criteria that they're looking at that may not be the same as a risk determination. And so, which is an interesting thing. And so I'm working with a couple professors in psychology now, trying to put together an article in Psychology, Law and Psychology. You know, it's going through peer review, you know, at the moment, and it still needs some work on it. But the idea is that on the one hand, you have psychology who has these criteria that they use to determine risk. And on the other hand, you have the criteria that the USCIS uses to determine risk. And what it looks like to me is the criteria that the USCIS uses isn't based in science. So, the question on the statute, okay, the question on the statute is if the Secretary of Homeland Security has the responsibility of determining risk, what is determining risk if it's not a risk determination? Psychology says, well, risk determinations are like this. USCIS says, well, risk determinations are like this. So my question for psychology is, what's the USCIS doing? And the psychologists are looking at what the USCIS are doing and saying, I don't know, these are called unstructured judgments. Unstructured judgments is when people sit back and, like Freud, you know, where you listen, or what Freud's a psychologist, but an old one. But the point is where you sit back and you judge somebody. And I can see the USCIS criteria is coming out of immigration. A lot of their principles are coming out of immigration, but they haven't really crossed over into psychology to say, do our criteria have anything to do with probability statistics, the chance of somebody doing something, right? And so so when we hire psychologists to work on case clients, they're thinking about their mechanical models, personality, you know, is there any aggression? Has that been resolved? You know, we're thinking about all these things applying to the client, and to get them to turn their attention and say, you're doing a good job reporting what your findings. And I get psychologists calling me on the phone, it happens sometimes, and says, I don't think you should proceed with the case. Well, why is that? I go, there's some risk here. The original offense had something to do with alcohol. The guy's still drinking. And when you talk to him, there's a little bit of belligerency in there. So there's some issues going on. So sometimes we'll take a case and we'll stop it because I'm actually looking for the real answer. I want to know from the psychologist, is this case worth proceeding on or not? I'm not interested in being a hired gun. That's not what I want to do because it's not helpful to the client, in my view, and it's twisting the arm of psychologists to give a result that they shouldn't be giving. So I don't want psychologists to do anything more than what they need to do their job. And so then my question for the psychologist is, okay, so we've got a situation here, the guy loves his wife, he's got a drinking issue, would treatment help? The answer is yes. About how long would that take? He said, I don't know, put him in treatment for 6 months on alcohol abuse, and then come back to me, we'll take a second look at it and see. So my question to the client is, alcohol or spouse? I mean, it doesn't matter to me. You know, it's what you want. And in a couple cases where you've got these issues coming up with some kind of behavioral issue like that, they've always come back choosing the spouse. They've gone into treatment. They've actually done better. So family being together is a motivating factor. And if it's not, if the alcohol is better than the spouse, then the relationship isn't going to last anyway. So it's these kinds of issues that I go through when I'm talking to psychologists, talking to petitioners, and then you get to talk to the beneficiary or the foreigner. And she's the one, or he's the one. We've got same-sex couples, both male and female. You know, I've got females who are petitioners, the husband is the immigrant, and so forth. And so the question for the beneficiary, the foreign beneficiary, whoever that is are you in it for the green card? I mean, that's going to be the USCIS officer's take, right? They want to know U.S. is from U.S. government standpoint. U.S. is the greatest place in the world. There's no other better place on earth than the U.S. So if you're going to connect with this petitioner who's got that criminal offense, it must be for the green card. So the big question for the foreign beneficiary is, how did you end up choosing this relationship? And why don't you guys live somewhere else? I mean, the U.S. doesn't, you know, if you come from China or go live in China, is that a problem? Can you go live in China? A lot of times you can't. Because the guy who has the offense can't immigrate to China. So there's some problems there. My question is, how do you stay together in a relationship if it's a good relationship? And a lot of times the foreign beneficiaries are incensed because they say, how is that law protecting me? If I love my husband, we've been living in the same house in the United States for 12 years, 10 years, 7 years, or whatever it is, there hasn't been any incidents, no domestic violence, everything's fine with our relationship. Why does the government care? It's a valid question. I mean, this is something about our culture, you know, that I was in an adjustment of status interview with the client, and the two adjudicating officers sitting there. One of them was I don't know, willing to listen, but the point is that he was willing to ask questions that were objective and try to figure out what's going on with these. And the other one, who I think was a supervisor, younger, and oh boy, I'm suspecting she was an attorney, I don't really know, but her line of questioning was really sharp. And all she did was ask her questions, very pointed questions. And then when she heard something derogatory, she goes over to the computer, types it in, and then keeps going on with the interview. So she's obviously hunting to kill. I mean, this is a predator. This is a USCIS officer who's a predator. So you're going to get that, you know? And then the USCIS, interestingly enough, the USCIS decision came out and actually listed all of the derogatory comments as being the reason for the denial, which I like because I was there, and the whole time we were in the interview, I was taking notes myself. So I could write an affidavit explaining context. So what she was doing was hunting for words that had negative context and was putting it as a litany of reasons for denial. But based on my notes, I go back and put those words in context. And so when you put it in context, it wasn't negative. So there's a question of an officer who's not going to approve, and then what do you do with it? You get that kind of denial and stuff. You file the Board of Immigration Appeals, but you don't. I can show you some cases that say the Board of Immigration Appeals doesn't want to hear this stuff. I could say, okay, we can file it in federal court. We could refile the case. Try to get a better adjudicator, which we've done in this case. Or we could jump into a different kind of immigration, or go in a different path. Please.
Question: going to the Board of Immigration Appeals, do they take a position that they're primarily reviewing the application of the law and tend to stay away from facts and be deferential?
Yeah. No, what it is if you look at the statute, let's take a look at the statute really quick. How much time do we have?
Till 2:30.
Okay, so we have a little time. Yeah, I'll show you the statute first. Here. So I meant to do that much earlier, show you the actual statute, but I find the statute really interesting. So it says a U.S. citizen or green card holder is barred from petitioning, which is interesting, barred from petitioning a foreign family member, which to me means that they're prevented from participating in the immigration process. So then the question arises, so if we're filing a petition which you don't actually have to do under the statute. But let's suppose you're filing a petition with the immigration agency so that you make a no-risk determination. Do immigration rules apply at all, right? Because this says before you can participate in that process, you have to get a no-risk determination. So one question is Department of Homeland Security, under the statute, the Secretary of Homeland Security, comma, in the Secretary's sole and unreviewable discretion, determines that such person poses no risk to the intended beneficiary. Okay, so how, number one, how would the Secretary do that? Why not Department of Health? Or someone else? I mean, if what we're talking about is risk determinations, okay, so it's interesting that Congress made that choice to grant that power to the Secretary of Homeland Security for them to delegate. So then another question, so why are you delegating to the USCIS? If the question is, you can't participate in immigration until you first get a no-risk determination. So, I mean, that's an opening volley. So when you see decisions from the USCIS and Board of Immigration Appeals talking about immigration rules, immigration this, I'm not sure that, I don't know yet how immigration rules necessarily apply to the statute. Maybe it does, maybe it doesn't. So when we get into the legal issues, it runs a long course. And so for me to do this research on my own over a long period of time is not easy because I don't have a big office with a big staff. But I do notice things in the statute that I think raise some serious questions about the interpretation of the statute. So it says there, for example, barred from petitioning for a family member if that petitioner was convicted of a specified offense against a minor under 18. So the question that can be right now for the Board of Immigration Appeals is whether the case itself, whether the conviction itself, is a specified offense, or whether it falls under the Adam Walsh Act. There's one of the approvals, or it's not exactly an approval. One of the cases that you've got in there is that we argue that the statute doesn't apply, and without going to the BIA, the Board of Immigration, the USCIS agreed, and that was kind of it was really subtle argument in how to get that done. But the first question is do you even have a specified offense? And is that something that would prevent you from proceeding with the petition? We've got other cases. That one was listed among our approval cases. It's actually not an approval. There's one of them in there. But so I didn't delete it because it's actually a good example. But there's other cases like that that we've got, and other offices. Other offices besides our office. Was convicted of specified offense against a minor under 18 unless. So you can't do anything in immigration unless what? Unless the Secretary of Homeland Security, in the Secretary's sole and unreviewable discretion, determines that such person poses no risk to the intended beneficiary. No risk is really interesting. So Congress can say no risk, but then it's up to the agency to define what no risk is. And if they're not defining it, what are you supposed to do? That's the kind of question that might end up in court, number one. Second, is that the Board of Immigration Appeals here in matter of CS squared Quiros, I don't pronounce that word correctly, but you've got these three decisions that came out of the Board of Immigration Appeals in 2014 that basically trashed the AWA cases. And what the first one says, CS Quiros, how you pronounce it? But it says that the Board of Immigration Appeals, which is the administrative appellate body who reviews I-130 or immigrant petition denials, that's so when you're trying to find out if somebody falls under the Adam Walsh Act or not, you've got to file a petition. So in general, in immigration, you've got a U.S. citizen or a green card holder who wants a foreigner. The foreigner could be in the U.S. or could be out of the U.S. The thing is, you got somebody that has a governmental interest. The U.S. has an interest in that because we've got a citizen or a green card holder who wants the foreigner to come into the U.S. or to stay in the U.S. or get legal status or whatever it's going to do. There's a blinking light coming on the U.S. side. That's the petition. Once the petition gets approved, then you've got the foreigner who comes to life, and the immigration agency says, do you want to immigrate to the U.S.? We've got a blinking light going on here. Yeah, so you've got a petition process and an application process. That's the nuts and bolts or basics of how immigration generally works. So what the Board of Immigration Appeals is an administrative appellate body in the Department of Justice. So the USCIS and most of the immigration agencies are working under the Department of Homeland Security. But if you have a dispute with the Department of Homeland Security, you kick the petition denial up to the Board of Immigration Appeals and see if they agree or not. So there was a lot of litigation that was going on between, I don't know, about 2010 and 2014, right in that time, where people were filing because they're saying, for whatever reason, we can get these cases in the federal court, and then the U.S. Attorney's Office was settling the cases, so or not, maybe they would fight or something. But when the Board of Immigration Appeals came out, the Administrative Appeal Office came out and said they lack jurisdiction to review a no-risk determination by uses, including the standard of proof. Now, this is interesting, including the standard of proof. So, if the statute says, Secretary of Homeland Security, Secretary's sole and unreviewable discretion. So somebody has to make a decision. Yes, no, it's like a jury. Yes, no, you're guilty or not guilty, right? But there's someone else that tells the judge or tells the jury, and here's the rules you got to follow. If you're going to find somebody guilty of murder, you got number one, the victim has to be dead. There's certain rules. So when you go back in the jury room, there's certain things there's elements here you got to decide, right? And so ultimately the jury says yes or no, guilty, not guilty, right? But so that's what the discretion is about. Okay? And this sole and unreviewable discretion, so the Secretary's sole and unreviewable discretion, determines that such person poses no risk to the intended beneficiary. That Secretary of Homeland Security determines that person. So you can't do anything unless the Secretary determines the person poses no risk to the beneficiary. Okay, so one question I have is, so you've got the discretionary determination. You've got the discretion to decide. What about the determination? So that's questioning about, what about the rules? Who makes the, you're playing Monopoly, you throw the dice, but who makes the rules, right? So the Board of Immigration Appeals says, matter of Cities Quiros says, Board of Immigration lacks to review a no-risk determination by uses, including the standard of proof. So they're saying uses gets to make the rules, and they get to decide the case. So whatever rules they're going to make, however they decide the case, the Board of Immigration Appeals is not going to get into it. So does that trash any kind of legal argument? It might. But just keep in mind, Board of Immigration Appeals is under the Justice Department. So you've got the Department of Homeland Security who controls uses, and that's who's making the, hang on just one second. And that's who's making the discretionary decision. But uses is also designing the rules. The statute doesn't say what the rules are, right? So uses is designing the rules and making the discretionary decision. Board of Immigration Appeals says, we can't get into that. Because Congress said uses or the Secretary of Homeland Security has sole and unreviewable discretion. We're the Justice Department. So I don't see anything in the statute that says that we can give oversight to uses. That's not exactly what the statute says. But what they're saying is, look, if we don't give uses or the Secretary of Homeland Security the standards for determining how they're going to make their decisions, then what sort of discretion does uses have? The discretion to decide or rulemaking or both, or what is it? So the Department of Justice backed out and said, we're not going to give oversight to this. That leaves the federal courts. So it makes sense to me that if you've got the Department of Homeland Security saying, we've got the power, we've got God's power, and the Department of Justice saying, statute says sole and unreviewable, so I don't know how we can interfere with that. What is that? That's a question of how to interpret the statute. So it would make sense to me that the Justice Department is saying, we don't think we can get involved in the discretionary determination or how the rules are made in order to make that determination. And you might have to go to federal court. Okay, so then the question in federal court is interpretation of statute. What is the law that applies in the case, and are there any constitutional infirmities? That's a long haul to get into that stuff, and I do. But so I'm going to stop there for 1 second, but because you have a question here. But hang on, if we go back and look at the statute, unless the Secretary of Homeland Security in the Secretary's sole, why did they put a comma? Why did they put a comma there? In the Secretary's sole and unreviewable discretion, comma. So we got the discretion, and we've got the determination. Are they different or are they the same? Board of Immigration Appeals says, well, sole and unreviewable applies to both, but there's a comma here. So it's a question of for the courts to know, what did Congress intend? And it's a question for the psychologists that I work with, the professors, to define what is a risk determination. What is that? In other words, can you throw bones in a bowl and say it's like, if you get snake eyes, you win. And can uses be arbitrary and capricious in its decision-making process and how it does its rules? Well, sole and unreviewable suggests that the Administrative Procedures Act, which contains a clause for arbitrary and capricious behavior, they've eviscerated it. Congress may have eviscerated another set of statutes that says that the Secretary can't be arbitrary and capricious in its decision-making. So if sole and unreviewable means the Administrative Procedures Act is eviscerated, does that also mean that the deciding agency can be arbitrary and capricious? I don't know. Well, if Congress intended the uses to say, we're going to throw balls in the bowl or whatever we want to do, don't look behind don't look into the kitchen, don't go behind the black curtain. Judges don't go back there. If that's true, then why is there a comma there? So it's an interesting way of trying to understand the statute, whether there's a distinction between discretion and determinants, and why do you put words in the statute if they mean the same thing? So there's a whole bunch of research that I will do into that area, and I really like talking to really smart attorneys because I'm not that smart, but there are some really great attorneys out there. So my job is to tee it up. So I'm laying the groundwork in psychology so that greater minds than mine can actually dig into statutory interpretation, constitutional issues like that. How that plays out eventually, I don't know. But I do think that you can't. Determining risk is probability statistics. It's not moralizing. It's not saying I like you or I don't like you. It's not discretionary determinations. Discretionary means equitable balancing, good factors, bad factors, totality of circumstances on whole. I don't think that's what the word determines means. Determines has a scientific basis. So did Congress intend the Secretary of Homeland Security to not use science as a basis for risk determinations if it's a hard science? You can actually do studies. You can figure out probability statistics fairly accurately. And why would Congress allow someone to determine risk if they didn't mean determination to mean something? So that's an area I would like other attorneys, bigger and better attorneys than me, to help or at least give support in that area. And I've gotten some signals from some fairly prominent attorneys, including my law school professors in the Supreme Court a number of times, to start looking at this to give some feedback. But I'm pretty much the one carrying the ball because I can't break down that statute correctly without first understanding what a risk determination is in the field of psychology. So I have to go to the professors first, get that all sorted out. So what we're doing is laying out an anatomy. This is how things are sorted out in psychology. So then the question is, what is USIS doing? Why aren't they leaning towards science? So, let's say the reason we're leaning towards science is because we like to have the power. We're circling our wagons around ourselves, and we just like to have that power. And we don't really want to define terms. We don't want to be clear about what we're doing because we just decide if we like it or not. Well, then the question is, from a constitutional standpoint, from an interpretation of law standpoint, is that good enough? That's really hard. That research is really hard to get into. So I'm trying, and I'm pushing in those areas, but it's a big move. It's a big move. So a lot of times clients will call me and say, hey, obviously, this is an unconstitutional equal protection due process. This is tough stuff. This is some of the toughest stuff that I've run across, and I think there's a thread to pull. I just think so. I wouldn't have gotten a call from. He's the most famous immigration attorney in the United States, and he thought that I hit on something. He read something that I was writing, hit on it, called me, said, and then he gave advice and suggestions on where to pursue. So that office is busy doing other things, so it's left to me to go battle it out somehow. So it's a long game that I'm playing to try to figure out what are the chances of success in getting the USCIS to reintegrate statutes. And in the meantime, when we're presenting our cases, I don't want to argue with anybody. I don't want to do battle with the USCIS. What we mean by compelling case, bringing forward a compelling case, is that I'm trying to put our cards on the table from a client standpoint, put an anatomy of the case out there, good points, bad points, with the imperfections that they are, and asking a fair question. What does that have to do with risk to spouse? And the risk to spouse has to have something to do with safety. So you've got a sex offense involving a minor child, and how does that connect to the violence issue? How does that connect to domestic violence, emotional abuse, that kind of stuff? If you want to draw the connection, that's fine, but you have to draw it. I'm not seeing that. I'm not seeing these systems doing that. So it's a good question for courts to figure out how should we handle these cases? Does sold and unreviewable mean the courts just don't get involved at all? Or is there an opening there in the design of the statute to be able to help the courts give guidance to uses? So in the meantime, until we get a decision from the courts, which I don't know if we'll ever get, but my wish is that we would, until that happens, how do you present a case to an immigration officer who has life experience and maturity to look at these immigration cases in a very simple way and ask themselves, what concern do I have for this? Yes, there's a criminal conviction there, but really, these cases aren't that hard. They're only hard when you put on colored glasses and you imagine, you imagine somebody could bump you and push you down the stairs because that's humans. We're all alive. So there's always going to be some kind of risk out there, but what is a valid risk that has some concern for the immigration agency? That's what makes these cases really tough, in my view. That the answer is pretty simple. But how to get there, you have to go through miles of social conditioning, cultural conditioning, abuse. And sometimes, it might be a mindset of officers who just won't let it pass them because they're skeptical, or they're afraid, or they had experience with a child, they had a spouse, domestic violence. There's all kinds of reasons why adjudicators themselves will back reticent. My apologies that took so long, but your question.
Relating occurred to me, and you pointed out the process as an argument. You'll remember back when we had a different Supreme Court in the 70s, some state regulations, which means state were not actually under congressional. There was a driver's license restriction, adoption restrictions, and back then the Warren Court used due process to get to those. And this would seem to be the same thing. If they wrote a statute which insulates them to the same degree would be if there had been a local ordinance or a state statute. It's all insulated.
Right.
What does that leave except a due process approach?
Right. Well, interpretation of statute, I think, is a little bit stronger. Constitutional approach is really good, I think, but it's hard. It's even harder to get at. So I mean, like a related question to that is if the state's criminal justice systems are keeping a lockdown on the petitioner, then why is it that the federal government has weighed into the state process to be able to determine whether or not you're safe in the community? I mean, one of the questions for psychologists, for example, is when you get like a certificate of rehabilitation, or you go to level 1, or to your registry, or whatever. At whatever point you're no risk to the community, does that mean that you're also no risk to somebody in your household? So the question there is, if you're walking down the street, you might not be risked in the general community, but what happens behind closed doors? And so an immigration officer could be thinking, okay, so out in public, this couple's okay, but maybe behind closed doors, there's still some kind of issue or something going on there. That's how they feel about it, So the question for psychology is, when you say no risk to the community, does that include in the household? The answer that I'm getting is yes, it does. I don't know that for sure because they need to see the studies. So this is a question I have in terms of some kind of what is it, APA? It's some kind of law and psychology article. Is to what extent do the mechanical tests that they use to determine risk apply to when you're granted to come off the registry or level 1 or whatever says you're no longer risk to the community, how is it that you're still possibly a risk in the household? Because USCIS isn't following. Isn't following the state guidelines or SORA or whatever it is. But they're sort of going off a different path. And I think part of the reason to do that is they say when you're looking at tier levels or you're looking at just in general expungement things, they're looking at it from a community standpoint, which I think includes the household. But when you give it to an immigration officer who's not really familiar with the justice system, they say, look, I'm just looking to see if somebody's a risk to their family. They start thinking about what happens when the doors close. So there seems to be a bit of a disconnect between what immigration officers do, what the criminal justice system does. What you're potentially raising is look, our state criminal justice systems handle these issues. And so on the federal side, why is that not enough? Should this be a state's issue rather than a federal government issue? And I don't know the answer to that one because I haven't researched it.
Has there ever been a test on the concept of Missouri Railroad deference to the states and where you put this in that kind of?
Yeah, I understand. I understand. So right, because if let's say a couple's they're not knocking on the door to come into the U.S. You don't have like a spouse visa or a child visa or something. They're already in the U.S. Maybe entered as a visitor or something like that. Couple gets married. They've been living in Texas for 15 years. Immigration still plays a role, but I think what you're asking is why isn't that a state? If we're talking about crime, abuse, and so forth, why isn't that a state's issue, not a federal issue? I don't know. That's not the thread I'm pulling on, but it's definitely there, and I've wondered about that because it does seem more like a criminal justice issue. From an immigration standpoint, you've got Violence Against Women's Act. I mean, if somebody gets beat up, I've got a Violence Against Women's Act where the male is the victim. I've got a current client like that. So Violence Against Women's Act applies to both sexes, same-sex couples, whatever. It all applies. So you've got that remedy for people that are being abused in one way or another. So it just seems to me that that there are other features of immigration that sort of handle those kind of problems. So your question is, so why isn't the problem of couples living together in the same home a matter for the state criminal justice? There's a question. I don't know. Yes.
Yeah, just so this statute just applies if the offense against a minor, but the hopefully marrying an adult, your offense would have been with an adult.
Yep.
None of this applies. What's the premise on that from the government perspective? Why do they say it's minor, this applies, and it's adult, none of this applies?
Yeah, because the statute is being interpreted as a two-step process. So first question is, do you fall in the bucket? Do you have a specified offense against a minor? If you do, prove that you're not going to, burn a house down, or that you're not going to steal candy from a kid, you're not going to go on a boat drunk, prove. There's all this stuff you got to prove, and one of them is, well, there's not all this stuff you got to prove, but in your imagination, if you've got that offense, now you've got to go through the factory. You've got to go through the rigmarole. So what it is these are two independent processes from an immigration standpoint. So if you fall into the bucket, you've got to climb out. And that's where you go into the no risk determination, where you start running into trouble, especially in cases where there's no aggressive violent behavior. I mean, I can exaggerate, but let's suppose you have full-blown pedophile. All the people in the world, this person likes children under 5. What does that have to do with risk of harm to a spouse? I mean, pedophilia has a definition. And in most cases, sex offense involving children, we're not talking about pedophilia. But I'm just saying, there's a medical definition for a mental state that, the concept of pedophilia is defined. So when you ask a psychologist, does that person pose risk to the family members? The answer is no. Because they have a specific condition or specific issue. That's my apologies, I'm exaggerating, but to make your point there, yeah, the question of what offense I had and how that relates to my family members as an adult is a really good question. I would say, in general, if there was abuse, because specified offenses include false imprisonment, it includes kidnapping, it includes offenses that do not involve a prurient interest. For example, you see on one of the approvals there that voyeurism is one of them. So voyeurism is a wobbler. You could have a prurient interest, or you could just be looking. So when you look at the various statutes that you have, the specified offenses, they all have different motivating factors. And so a lot of times, motivating factors don't have much to do with abusive behavior, physical or emotional abuse. A lot of them don't. So you have mental states, knowing, reckless behavior, intent. There's all kinds of stuff that you look at. And in my book, you would think uses, so the people that are administrating the AWA statute should be looking for abusive behavior. If you find it, then it raises a red flag. But if there's no abusive behavior, then what's there to see? It's kind of a fair question. And I think what happens is uses says, I still don't feel comfortable. So my job is to try to lay out a program that's honest and forthright and clear, so the USCIS officer can start getting into the comfort zone. They're willing to keep reading. If you make mistakes in your presentation, at a certain point you've lost the audience. Once you've lost the audience, they're going to deny you. So how do you keep them reading? You got 500 pages. It's difficult. They got a bunch of 50 states, or including offenses overseas, but you've got all these statutes, and they need to be characterized and interpreted. And so part of my job is to make things digestible for the immigration officer. Because in their mind, you've got a 100-yard dash, right? And the petitioner is starting 30 yards behind the starting block. So how how do you give the petitioner a fair chance is you have to neutralize all the biases, the hidden biases, expressed biases, but hidden biases. So that's what I try to do. And that's why sometimes you get these approvals. Because I have a couple cases where the case was approved. One was in the Philippines, the fiance visa, and the case was approved and went out to the Philippines. The Philippines sent it back saying, this must not have been reviewed, so we're not going to accept this case. It took about 2 years, and Vermont, who's the main body that's adjudicating the onerous determinations, said, yeah, we approved, we went through the Adam Walsh Act, we need it. So his wife is in the US now. But sometimes you get agencies who disagree. I had another case in Santa Ana. And the immigration officer said, it's a mistake, you shouldn't be here, we don't handle these cases, and it's going to have to be shipped back. And I said, okay, fine, it's going to get shipped back to Vermont. I said, but you have it, you've got the couple here now. Would you just take about 10 minutes, maybe just talk to them? Write notes, good notes, bad notes, whatever you think. Maybe you don't like the couple, it's okay. Just write your notes, but at least you saw them. The people in Vermont don't see, they don't see this couple. And whatever your impressions are, just go ahead and say them in a second. And then the officer sat and talked to this couple for an hour and a half. And she said, I'm going to approve. Well, why? Okay, thank you. But no, I'm just saying because they're rare, but she decided she's going to go ahead and approve. Vermont challenged them. Took 2 years. Vermont challenged them, and the director in Santa Ana go back and said, yeah, we approved. Because this officer was mature, she had life experience, she looked at the couple, she was listening to what they had to say. She, it took her a couple of weeks to go through the record, but she approved. So those are tough. Those are tough to get those, but they happen. Somebody was in the back. We finished?
We have 5 minutes.
Okay. Is there anything more that I can offer for you? No, sir.
2 questions. First one is, does longevity of the relationship ever factor in? In other words, is a relationship that went for 20 years more likely to be approved for the immigration than one that's been for 2 years?
Yeah.
Does that factor in at all?
Thank you. Yeah, if you look through the cases that we've got approvals on, I can't find a pattern. I mean, some cases, we're immigrating someone in from overseas and they got approved. And I'm not saying it should be a surprise, but I'm just saying that's longevity. I've had other cases where couples have been together for decades and they're still not getting approved. So I'm thinking we can present a good case. The question is whether anybody on the other end is listening. That's really the question. But in terms of getting into court, absolutely. Absolutely. Because, I'll tell you really quick, because there's a concept of desistance in psychology, and basically it says when someone commits a criminal offense released in the community, every 5 years after release, their risk of sexual recidivism cuts in half. Right? So after 10 years, you reach the level of desistance where you're no longer a threat to the community or anybody. You've kind of reached that. You're the same as everybody else. And once you hit that desistance level, I'm not seeing the issue. So
the other question I had was, this may be a little bit outside what you're talking about today, but have you seen instances where green cards that have already been approved get revoked as a result of a spouse's status?
Tried. I've had a couple cases where another agency has tried to revoke. I don't think they can, because there's a rule on revocation that if the issue wasn't addressed, you can revoke a green card, whatever. Because they missed a spot, they didn't catch it, right? But if they actually looked at the Adam Walsh Act issue and approved the case, there's no turning back. That's been adjudicated.
I'm talking about an offense that happened after the immigration. Say the immigration 2
Oh.
years ago, and then you have an offense now. It's possible to go back and revoke something.
No, because the immigration decision is made.
But like renewals as well for the spouse.
Oh, good question. I think it would, because because once you're issued a permanent resident status, you're talking about for a marriage less than 2 years, where you're filing a 2-year. You've got a green card for 2 years, and you're filing to validate the marriage 2 years later, as compared to 10. So if you've got a green card for 10 years, it's pro forma. As long as you follow the rules, it's just a green card expired. You got to get a new picture and file. But you've had a green card for a long time. Where that comes into play is when you've had a marriage of short duration. So the USCIS will approve a green card, but they approve for 2 years, and then they make you file removal of conditional status, right? So, but the thing is, some people think that the green card is only for 2 years. It's not. Permanent residency means permanent. So it's called a condition subsequent, where what you do after 2 years is you file to remove the condition by saying we're still in marriage. But the fact is, the green card originally was approved permanently. So I don't see how they can go back and replicate the Adam Walsh Act unless they hadn't addressed the issue before. So there should not be a problem with the removing the 2-year condition status. Should not. In my view, I think we've got the better argument. Yeah.
They're not open at all.
Okay. Well, thank you for sticking with me.